figured out how to do the live. I think we're live on video
Oh,
because I think the
great.
problem that
Oh no.
with the when I set you up on hosting, it cut me off, and now
Oh no.
I think it's the YouTube is working now, just
Yeah,
now. Okay, and everyone, please forgive us. We just don't know how to do this properly. Let's see. I think everyone can just put on their video on their own and put on their microphones on their own, I believe. And so let me see if how to do this. In the meantime, Professor, please, in, walk
oh,
us through a little more if you can while we try to fix these issues. I've
sure.
just so I'm allowing everyone to have video, and then people can have raise their hands. Start video. Video. I think everyone uh, to can do their own video. Um, anyway, well, here in the state of Florida, the only people that are participating in this event are those of us who are certified for Spanish.
Mhm.
That is, I would say, more than 90% of the court interpreting that is done here in the state of Florida. And well, there are lots of issues regarding this. Basically those supposedly, according to the Florida Supreme Court, only those who are certified, or in other words, those who use our services, have to go to, first of all, to fully certified interpreters first, and then go on the line to provisionally approved, to registered, and then non-certified. But that's not what happens. So we have a lot of agencies working out there who, in the middle of this pandemic, are asking us to cut our rates. And what's interesting is that among some of the participants, we have some people who are agencies, and we have some issues with that, and we're trying to see if maybe with this debate we can work towards a solution. And also, we have those who are court certified but are court staffers, so they don't have the types of issues we freelancers have. And of course, none of this is applicable to any of them. So as I'm speaking, I'm telling people to start their videos. I believe we finally managed to make the YouTube work. Um, so it, I'll start with a question. Given our specific situation,
Mhm.
what can we specifically do without running afoul of I believe, the Sherman, the antitrust law, or any law for that matter,
Mhm.
and yet get together? From what I read in your article, what we can do is form either a corporation or a cooperative, some type of entity. So how do we do that?
Okay, so yeah, so what you can do now is you can either individually set your rates without coordinating at all with each other. If you start to share information with each other about what you're planning to charge for your services or what your costs are or things like that, that can run you in violation of the antitrust laws. And so, but you still can, of course, act unilaterally by yourself. If you want to be able to coordinate with each other, you're going to have to do something that comes within the exemption of the labor laws of the antitrust laws, either under the labor exemption to the antitrust laws or basically under corporate law. Because you're unlikely to be found exempt under the labor exemption, because you're not likely to be found to be essentially employees, um, your best option is the corporate law route, right? And so basically forming some business organization, and it can be a range of options. Again, it can be an LLC, a worker co-op, a S corp, right? Like there's a corporate attorney can advise you on that. Either if you want to incorporate in Florida, or if you want to incorporate under any other state law, right? You don't have to incorporate in Florida if you, even if all of you reside in Florida. A lot of corporations, for example, incorporate in the state of Delaware because they have really, they're known to have really beneficial corporate law for corporations, and so some firms just opt to incorporate there. But so long as you're operating as a single corporation that's unilaterally setting your rates, you can do anything within the bounds of the firm to share information, to decide who you want to deal with and who you don't want to deal with. If people are wanting you to cut your rates, you can decide not to provide services to them unless they accept the rates that you're offering and things like that. Oh, I think you're on mute, Javier. I'm going to unmute. Sorry.
Hear us. Hold on just a second. Ask to unmute. I am asking to unmute. And let me see. Well, she just lowered her hand, so she doesn't have a question. So that anybody who has a question has to basically raise their hand, and then we'll go to the question. And please excuse our lack of knowledge of Zoom etiquette. Professor, please go on.
Yeah, no, I think Angela did raise her hand. So
Yeah, yeah, she's raising her hand. Her mic is on.
yeah.
Angela, we're listening to you. Please go ahead.
Okay, thank you. Professor, one of the things that you said that struck me is that when you say that we cannot share information as to how much we charge, can get us in trouble. I've always been very open sharing, because what happens is, even though there may not be a set agreement among the agencies, there is some sort of agreement among them to bring us to the floor with the prices, and they do manage to do so. A lot of people give in. What I have found is that as I share what I charge, many of the other interpreters decide that maybe they can go for some higher rates. Um, there is nothing in writing saying, yeah, I charge these. Why don't we agree for you to charge this much? I just share how much I charge, and it's up to them whether they want to raise the rates or their fees or not. There is nothing per se as an agreement. It's each one acting individually. Yet I do share how much, I mean, it's how much I charge. It has been my decision to charge something, and I am sharing how much I charge and how much they agreed to pay me. And I have a little bit of trouble when you state that by sharing, we get in trouble, because that is not an agreement per se. So could you expand or elaborate on that?
Yes, yes. Okay. So to be clear, in what can violate the antitrust laws, it can be a written agreement, it can be an oral agreement, it doesn't have to be written down. It can also be something where the court looks at what you did in sharing information, what the resultant conduct was, and it can infer an agreement. So this is what's really tricky. This is the trickiest part of Section 1 law, because most people know basically, like, we're not allowed to, reach written agreements on prices. They know that. And so what they usually do is they try to avoid liability and but still get to the same result by just talking with each other and sharing information. So there are a number of cases where both the Department of Justice and the FTC have gone after antitrust defendants for reaching verbal agreements, or not even reaching verbal agreements, sharing information alone, and then uniformly acting in response to the sharing of information to set their prices at the same rate, right? And from that, you can infer an agreement, right? And so this is a complicated area of law. There's no question that information sharing can be part of a charge that the government can bring against individual firms or individual actors who are otherwise competitors with one another to coordinate with each other. And so it doesn't matter if, again, it doesn't matter if you actually reach a written agreement. It doesn't matter if you've actually reached even a verbal agreement where you're not even saying to the other person, okay, here's my price. Will you charge the same price as me? And the person says yes. That obviously violates the law. But even something that isn't that, right, where you just share the information, there's winks and nods, and the person is like, I see that that's what you're charging. Now I'm going to charge my own price, and I'm not going to tell you what I'm going to charge. And then they charge the same price, right? And so from that, the court can infer that you agreed. So and this is how a lot of firms now are found liable under Section 1, again, because a lot of them are savvy enough to know that you should not put that kind of stuff on paper and you should not reach formal verbal agreements to fix prices. But nevertheless, the courts can infer an agreement based on your sharing of information plus the resulting conduct that happens after you've shared the information. And I'm happy to
even though the resulting conduct is not something that you agreed to, even though it's just you shared information, the other person acts on its own.
Yeah, even then. Yeah. And the court, what the courts will do is what they look at in inferring an agreement, they look at industry conditions, they look at facilitating practices within the industry, things that make it easier for people to collude with one another. And based on all of those things, it's kind of a circumstance specific, fact specific inquiry that the court engages in. They'll make a decision about whether or not they can infer an agreement. Yeah. I mean, it really depends. If the industry is highly concentrated, where there's just a small number of actors, they're more likely to infer an agreement. If it's a group of you, hundreds of you, thousands of you, it's pretty unlikely. But the law on the books is that you can still violate Section 1 engaging in a price fixing agreement if the courts can infer an agreement from your sharing of information and the conduct. And so if you want to read more about this, and I'm happy to send more cases on this that and maybe some articles that explain this, but if you Google like Section 1 information sharing, the Department of Justice and the FTC put out guidance. It's called a guidance for human resource professionals. You know what? I can link to it here in the chat, and I'll look for it. If I can, I don't know if I can.
There's no chat active in this session.
Okay. You know what? I'll send it to Javier. It's just a government document that was issued by the DOJ and FTC that really tries to spell out what can bring you within the scope of violating the antitrust laws with respect to information sharing.
Okay. One more.
Let me just write that down so I don't forget. Yeah.
Like this, 300 for about 2 hours.
And
One of those.
we're having a little difficulty here because I've unmuted mics and somebody's speaking. But anyway, so we're damned if we do, and we're damned if we don't. But from what I read in your article, there's a way to get around this, create either a cooperative or a corporation in Delaware, this and that. And so, what is the first step?
Oh, so if you are interested in forming a corporation, it's actually relatively straightforward, but you do want to have counsel. I would advise that you have counsel, just because knowing the nuances of the different state laws and what your tax obligations might be, what the benefits might be of the corporation, what the governance structures might look like, how you might think about whether or not you want to issue shares or not, how much capitalization you want to and you want to raise money to serve as a foundation for the corporation or not, which you have to do usually for an LLC, right? All of these are things that are highly technical things that a corporate law attorney would know. And so if you want to incorporate in the state of Florida or in Delaware or wherever you're in New York, wherever you want to incorporate, right, you'd want to make sure that you hire an expert in corporate law in those states. And they can walk you through the menu of options of what the benefits and the strengths and weaknesses of particular types of business organizations might be for the business that you want to build for yourselves. And then once you, essentially it's just about filing with articles of incorporation before your Secretary of State or the Secretary of State of wherever state you want to incorporate in. And then you have to meet all the requirements of the state law for establishing that.
I see we have Andres Mesolam, and I was going to ask him to ask a question, but he raised his hand before I even thought about that. So, Andres Mesolam, the former president of Association of Translators and Interpreters of
Javier,
Florida.
skip the titles. Doctor, thank you so much for giving us this lecture. I just have, let's say, I want to ask something maybe that could be done in a creative nature, like the thinking it outside of the box rather than following what's been said. Suppose, for an example, that I were to give a home economics course on independent interpreting. And it's just math. It's like if you want to make $10,000 a year, 50, 80, 120, considering there's only a limited amount of working days in a year, and considering that the nature of our work is that an assignment might last an average of so hour, well, what you're hoping for is possible, impossible, or you would have to charge so much or work so much. And there's no feedback from the audience whatsoever. Can that be done?
Ooh, okay. It's a very good question. So all of these are really great questions. So it would depend. It depends on what's happening before and after your lecture. What is clear in the law is when the law itself says, the statute itself or the courts say price fixing, they don't just mean fixing a price and saying, we want to charge X dollars an hour for our services, right? It can be an algorithm that you share. It can be a sharing of your costs, and then someone can infer what price you're going to charge, right? You can signal people, right? To say, oh, I think we would maximize our value if we maintained discipline, or this is the best way to calculate what you should charge, right? That also counts as price fixing. So it's very loosely interpreted. You don't have to specifically say your price in order to be found liable for it. And so if you just say, if it's like you're a trade association and you're advising new certified interpreters on how to run their businesses, right? And you say something like, this is best practices. You should, maybe form an LLC, and you should also, make sure that these are the standards of ethics that we apply when, we work with specific clients, and, you should have whatever, trauma training. And also, if you want to manage a successful business, you should make sure that you practice certain standards of accounting, right? And that you can probably anticipate that your costs for these types of services will be this, and you can probably anticipate that your costs for those types of services will be this. That's an average that I've collected and aggregated from all of the data, just so that that, so you can manage your own expectations in that way. That would be fine, right? But if you kind of cross the line to suggest that because your costs are X amount, if you want to be profitable, you should, charge prices that are a certain percentage above those costs or something like that, that can start to get into what's called signaling territory, right? And so what's tricky in the context of cartels and law about cartels is that a lot of it, because again, most price fixing cartels are composed of pretty sophisticated defendants that know that they can't come to formal agreements. So what they'll do is they'll signal to each other in all sorts of ways, right? Like to maintain the price discipline. And there's a whole range of examples of this in the case law where firms have signaled to each other through certain types of, for example, even on, shareholder calls or things like this, where they say, our costs are really tight this term. We need to make sure that we maintain discipline, right? That type of thing in the context of prices becoming uniform, right? People complying, right? That, can be found to constitute an unlawful agreement. But again, if it turns out that you make those suggestions and you're just educating new people as they're coming into the field on how to run their businesses successfully, and it turns out that you're all charging different prices, you're not going to be liable under the antitrust laws, right? Like you actually have to have some, like if you're not explicitly coming to an agreement with people and there isn't on the back end any uniform price increases that are happening, you're not going to be liable under the antitrust laws.
One last quick question, if I may. How close is this to freedom of speech?
Okay. So this is First Amendment doctrine is really, really complicated, as you know. So the kind of speech that you would be engaging in this context is commercial speech. It's not like speech about politics necessarily, so it gets less protection. And so a lot of, people have raised these types of defenses in the context of trade associations and other information sharing claims when, for example, the government has prosecuted trade association members or trade associations for engaging in price fixing. They raise a defense and they say, the government can't tell me what to say. This violates my speech rights, my First Amendment speech rights, if they're going to tell me what to say. But what the courts have said is that, you don't get speech protections for criminal activity. So if you're using your commercial speech in a way that is collusive, right, where you're coordinating with competitors to agree not to compete on price or other terms and conditions of provision of your services, that's not protected speech.
Thank you, Doctor.
But that's assuming that it in fact does violate the antitrust laws. So just to be clear.
A question. We have a chat in our association. Our association is called a TIF, and our president, Glenda, has been very careful about having us talk about prices because, of course, the association could be liable. But are we protected when we debate these things in our chat? I mean, the association's been careful to the point where the president said this event would not be of interest to the association. And I think that probably has to do with this third real concept is that, oh, we can't talk about this subject because we're going to get in trouble.
Yeah. So it is definitely within your First Amendment right to talk about, you know, what you can do collectively that wouldn't violate the law. That is part of being right. That is a right that you have as an American citizen, and even if you're not a citizen and you're here, you have that right. So of course, if you could be found liable for just talking about what does or doesn't count as legal or illegal, like literally every, you know, corporate manager would be in jail. so so clearly, like, you can definitely talk about, you know, what if we did this thing, would this violate the law? Absolutely. But if you actually go cross the line and then do the thing that violates the law, that's not, you don't want to do that. Right?
So, for example, in our chat, if we have an individual or an individual who represents an agency or an individual who's an agency, we have all kinds of things going on, and they post a job in our chat. Is that legal?
I mean, so I guess I might need to know a little bit more about like the context of what's being said.
So let's say there's a legal deposition at 2 p.m. downtown Flagler Street, Miami, Florida. Can anybody take this? Is that legal?
Yes, that's definitely, yeah, that would not violate the agenda. No. That's
But, but I'm offering you $25 an hour and I'm paying you a half an hour minimum. Is that legal?
yes. So even if you posted on your own website, right? This is what I charge for my services. That's not illegal, right? If other people see it, they see it. You know, you're advertising your services to the clients. Those are your rates, right? You can look at other people's websites and see what their rates are if they're posting their rates on their websites, right?
So what you're saying is from the standpoint of price transparency, each and every one of us in our own websites could start posting our prices.
You could, but you can get into murky territory if people start to notice that your prices are increasing in unanimity with each other, right? Because that's when you could potentially be getting into the zone of information sharing that a court could potentially infer an agreement from. So if you're coordinating with each other to do it, that could violate the antitrust laws. But if you are just unilaterally deciding that, as any normal business person would, as an independent contractor would, right? Like, you want my services, this is what they cost, and I'm advertising as I have a right to do, what the cost, what my rates are to the public, so that they can compare prices between interpreters. And
The other,
I would leave it at that.
right, but and how likely is that we would be prosecuted for something like that? I'm not encouraging anyone to go against the law, but I mean, I think we're small fry in the big context of things.
For sure. And it really depends. I mean, so what's so bizarre about this, to be really honest, is that when you look at the cases that the FTC has prosecuted, essentially the enforcement actions that the FTC has taken, they have gone after small fry. Like, it's surprising. Like, the Superior Court Trials Lawyers Association that they went after, they were a group of lawyers that work at the court. They represent indigent defendants, right? They're not a powerful lobby group. They don't have a lot of market power. They just wanted higher rates for their services. And the FTC filed an enforcement action against them. I think it's, honestly, if I'm being really frank, I think it's political, right? So I think if your increase in rates upsets the wrong people, they can file a complaint, right, with the FTC and request that they investigate your conduct, right? And the FTC, the FTC even accepts anonymous complaints, right? And they are trying to get information from anyone they can about unlawful conduct. And if someone files a complaint, say one of your clients, that all of a sudden all of you guys' prices have gone up at the same time, right? The FTC will look into that. and depending on its resources and depending on what the Chamber of Commerce is telling them, and depending on other kind of discretionary issues and priorities, they might go after people. And so I think the reason why, in part, they have gone after small fry in the past is to deter everyone from the bottom up, right? Kind of broken windows policing style, right? From coordinating. And so it's just, look, as an attorney, and I'm not your attorney, but if I were, right, it would be my job to make sure that you know all the legal risks. And then you make a decision once you know all the legal risks. And this is a risk, right? It's a risk to share information with each other, right? It's not unlawful to share information with the public, right? With your clients about what you're charging. And you can share information with your clients on your websites, right? Because you want the public to know what your rates are. But if you're doing that with each other, that's a problem. And if someone can infer that you're signaling prices through your website to each other, that can be a problem.
And then we upset the wrong people, then it's a problem.
Exactly. And what's tricky about, so there's two things. One is the government, right? If the government investigates what you're doing and files an enforcement action against you. It could also be that private plaintiffs under Section 1 of the antitrust laws can themselves file suits against you, right? So if a group of, say, agencies come together, like, what is happening? Like, all of a sudden, the prices for these services is so high, right? And they go and they complain to their attorney or whoever, and their attorney is like, oh, I wonder if they're engaging in a price fixing conspiracy. Let me investigate, right? And they look at your conduct and they look at if you guys have shared information, how you've shared information, exactly when your prices went up, if they went up at around the same time, right? So and they can file a case and say, oh, we think that these groups of interpreters are a cartel and they are agreeing to fix prices under Section 1.
So the only way to protect ourselves is to get together into some type of entity, corporate, or something that protects us.
Yeah.
That cannot be our association of interpreters because that's a nonprofit.
Yeah. No, and trade associations themselves they don't get the single firm exemption. Yeah, so it would have to be a corporation or some business organization, a business entity, right? So it could be any one of a menu. It could be a corporation, LLC, PLLC, partnership. Yeah, any of the forms of business entities that you can find within as creatures of state law.
And to get together to discuss that and to figure out how to do that, are we running afoul of the law in any way?
No, I mean, no, right? So if you want to form a corporation and you want to form a corporation to for all sorts of reasons, right? And so what you'd want to say essentially is that, as you're thinking through this, the way that I would recommend thinking through it is to say, how can you all benefit collectively from forming a single business entity in a way that would improve the quality of your work, in a way that would improve and stabilize your benefits, right? Your healthcare benefits and other benefits that you want, right? In a way that would allow you to ensure certain types of standards in the provision of certified interpreter services. You can talk with each other about how you want to do that and how you want to, what types of clients you would want to solicit. You can come up with a business model. And it's all to further your collective interest, right? It's if you frame it in terms of, oh, we want to establish a corporation so that we can agree not to compete, then the corporation is a sham, right? The corporation is just a cover for your cartel, right?
So,
You really want to talk about it in terms of what the benefits of a unity of control could bring, what unified decision making could bring to all of you in the formation of your corporation.
So let's say we set up a corporation and we manage to say have more than half of the certified interpreters or Spanish legal court certified interpreters for Spanish in the state of Florida in the corporation. That might upset some people.
It might, but okay, so these are costs and benefits that you'd have to think through, right? Who is it going to upset, and what's the worst case scenario that could happen if they get upset, right? And what benefits could you get on the other side, right? So would you have more strength being able to say as a corporation, you know what, you don't like it, we're just not going to provide you with our services. We're going to look elsewhere for the provision of our services, and we're going to provide other people with our services. These are the rates we're charging, and any corporation can do that, right? Like if, Walmart is negotiating with Coca-Cola for the prices of wholesale prices for Coke, right? And Coke is like, you know what, you don't like our prices, we're just going to sell to Target, right? That's not illegal. It's not illegal for Coca-Cola to say that to Walmart. And you as a corporation, right, you can say, I want to deal with, I can engage in unilateral conduct. I can decide who I want to contract with and who I don't want to contract with. And I can decide what prices I want to set for the sale of our services. And if you don't like it, go forth into the market and find other actors that you can contract with, and that's up to you. If you think you could lose the person you've upset, if you think that you could lose their services and still be okay, then you wouldn't worry about it, right? If you think that if they all came together and agreed to boycott you and that would be permanently harmful, then you'd want to think about that, right? And that's kind of one of the things I mentioned in the last slide. When I wrote the Uber article, it was a bit of a worse situation than you guys, right? Because, you guys really do. I mean, collectively, you guys really do have power, right? Because there's a certain number of certified interpreters in Florida that people can work with, and a lot of them are on this call, right? So you guys collectively could have a lot of power. But with Uber drivers, right, it's tricky because, right, they could be anyone. Right? They could even any of you. Some of you might be Uber drivers, right? Like you can do it as a part-time thing. You can do it as a full-time thing. And if you come together with your other drivers and Uber finds out about it and Lyft finds out about it, they can unilaterally decide, you know what, we can end this contract and we're not going to deal with you. And that you lose your access to a source of income in a way that's really harmful. And so that's a real concern for independent contractors when they organize, is if you're organizing together and you're dealing with a really dominant buyer of your services and they decide they don't want to deal with you, it's a risk, right? It's less of a risk though if all of the Uber drivers together are doing one thing together, right? If all of the Uber drivers together form their own corporation, right? And Uber didn't have any choice but to deal with that corporation because all of the workers are in that corporation, then what are they going to do, right? They can blacklist them, but who else are they going to get to drive their cars, right? And so, it becomes less risky. What other people think of what you're doing becomes less risky if you're all unified together. The more leverage you have as a collective unit.
I think we have a question from Angela Pedraza. Please go ahead.
Oh.
Your mic is off. Let me see if we can help with that. Let's go unmute.
Okay. Now
There we go.
Okay. A little bit of a parallel question or issue is that some agencies here, I'm new to Florida, relatively new. And what I have noticed is that several agencies send you a contract for you to sign, where all of a sudden in between all the garble, there is a paragraph where you, the interpreter, agree to pay for any legal costs that may arise from your work. I have refused to work with those agencies. I have been vocal with some of my colleagues in sharing that, because many people do sign the contract
Mhm.
uh, without even realizing that they're agreeing to cover legal costs for the agency, uh, when you may be getting paid $150 for a job.
Mhm. Mhm.
What is your take on that? Because that, I mean, the discussion of that, is that something that would harm us under the antitrust?
No, yeah, no. So I think it's fair game for the association to discuss and alert each other about ways that various contracting practices by other people might harm you,
Okay.
right?
Okay.
And so if you think someone is engaged, if someone's imposing contract terms on you that could harm you or harm your business, or that could be predatory, right? Or unfair, or create what are called contracts of adhesion, where they impose a lot of costs on you at the expense of the other person. It's definitely fair game to alert people to those types of contract provisions. You don't want to say, if you're the association, you don't want to say, do not sign these things. You might just want to say, these are the consequences. If you sign this type of agreement, you will be responsible for all legal costs. Those legal costs might include these types of costs, those types of costs, those types of costs. We estimate those costs to be around this price, right? Like, we think that could be, that can be costly in these ways. So just be aware that these exist. If you want to sign them, you can sign them. If you don't want to sign them, don't sign them. But you should just know that these provisions are out there. And so when you're signing contracts with agencies, you need to be informed about all of the different contract terms that they will offer. Yeah. And you can negotiate back, right? Like, you can agree to certain terms and not agree to other terms, and it is your choice.
Yeah.
Yeah.
Now, one thing that we may not have talked about is unions, because in the chat, every so often somebody says, "Oh, why don't we have a union?" And of course, Professor Hafiz, you're sitting in Boston, Massachusetts, and we're sitting here in Miami, Florida. I believe Florida is a right-to-work state.
Yep.
So, what does that mean?
Yeah. Okay. So the cases that some of the first two cases that I went over in one of the slides, and you know what, Javier, I'll also send you my slides, since the YouTube wasn't recording when I went through my slides. So I'll make sure to send you my slides as well as
And
that.
I will share via email with everyone.
Absolutely. Yeah.
Yeah.
Feel free to share. Let me just note that again. Send slides. Okay.
Or you
So
can put them up again. Yeah. Yeah. Yeah.
yeah, you know what? I could also, I don't know if I could do this, but if you could send me the link to the YouTube, maybe you can
I'll
add
send
them.
it to you right now.
I don't know if
Um,
I can do that. I'm like not super technologically
and
literate.
neither am I, and I think
That's
I'm
why
getting a failing grade on this.
I don't know if I can upload it as I could probably upload it as a PDF, but I'll just check with that, but I'll also send you a copy of them. Um, but
Okay.
but in the slides, there the couple two cases kind of from the mid-century cases, essentially, where what the conduct that was being evaluated by the court, that the government said was unlawful, was essentially a group of independent entrepreneurs that came together to form a union, right? And they were arguing, we're workers. We formed a union, just like other workers form a union. And we can come together to form a union and get all the protections that you would get as a union. under the labor exemption from the antitrust laws. And so you should treat our coordination as the coordination of workers in a union. And the Supreme Court looked at them and looked at basically the fact that these were independent entrepreneurs that didn't have a single employer. And they said, you're not a lawful union. You're using the union as a cover for your worker cartel. Because you're independent contractors, you're independent, you each have your own independent motives to compete with one another. And essentially what you're doing by forming a union is you're agreeing not to compete on price with one another. And so this is just, I mean, it's known as the independent contractor exemption from the labor exemption. Sorry, it's like a double negative, so it's confusing. But essentially what the Supreme Court has said is that if you're an employee under the National Labor Relations Act and you have, you're a W-2 worker for a particular employer, you can form a union and you can collectively bargain with that employer. If you're independent actors, independent entrepreneurs that come together and form a union, that union is not going to protect you from the antitrust laws. Yeah, you're going to need to coordinate lawfully with each other through some other means. And my view is that the only other means is through incorporating.
Now, one thing that you and I have talked about is, how the legislation favors employers in many ways. So, can this legislation be changed?
A great question. Okay, so yes and no. So of course, right now there's lots of proposed legislation, federal legislation, that is trying to reform the labor law, and some of those provisions have proposed at the federal level to remove the independent contractor exemption from the labor law. Okay, if that succeeds, then you could form a union. You would have all the protections of the NLRA, you could form a union, you could collectively bargain with whoever you want, right? With the people that you provide services to. The likelihood of that happening is slim. Who knows? Okay, so, and this all depends on the election. So with a Democratic Congress and a Democratic president, it could happen. However, when we had a Democratic Congress under Obama, there was a bill that was being pushed by Ted Kennedy, the EFCA, the Employee Free Choice Act, that was going to be a big overhaul of the labor law. He unfortunately passed away and we lost his vote. And it resulted in basically derailing the reform effort. There have been reform efforts from the 1970s until now to try to fix the labor law and to expand the protections of the labor law to independent contractors, and those have failed. And so it's a huge uphill battle. It's the one thing that the Chamber of Commerce absolutely fights against on a constant basis. And so there's a lot of like political weight to this question. And so it could happen, but it could only happen with a confluence of events, right? If we have this kind of blue wave in 2020, well, I guess we're here now, in November, that results in a change in our political landscape. That being said, there are ways of doing stuff at the state and local levels to change law. That's challenging in Florida. However, right, there's a way that you could potentially strengthen the powers of your trade association under and still have Parker immunity, right? And so there are a bunch of trade associations that are relatively powerful, right, in various states that regulate all sorts of the provision of professional services, whether those are medical services or legal services or whatever, dental services, whatever, interpreter services. And so So, you know, as long as you're being heavily supervised by the state,
We
there are
are.
certain things that you could do as a trade association to petition your government to strengthen under state law, you know, what your bylaws are, what your requirements might be, what the penalties might be, of folks who don't comply with those requirements and things like that. And that's all under state law. You know, I don't know, like, I'm sure there's politics that you all know way better than I do about, you know, how you interact with state regulators and how comfortable state regulators are intervening on behalf of various professional associations. But I think that state law can be an avenue for strengthening worker power, including through trade associations.
Now, one thing we haven't talked about, and it has nothing to do with rates, are conditions. For example, um, can the
Everything.
trade association say,
Mhm.
we recommend that everyone do a 2 hour minimum with a 24-hour cancellation? Is that legal?
Okay, so yeah, so this is where it gets into murky territory, and it was these types of things that came up in those three cases that that are also on the slides, in the Indiana Federation of Dentists, in the National Society for Engineers case, and also even in the Superior Trial Court lawyers case. Essentially, it's if you establish standards that have to do with the quality of provision of your services, and you're issuing them to maintain quality control, that's fine. If they're essentially ways of disguised price fixing, then you can get into trouble, right? So if you say you can only work this number of hours, like any one interpreter can only work this amount of hours in a month or a year or something like this, right? That's a restraint on the labor market. That's saying we're only going to allow a certain amount of output, and just laws of economics, right? If you reduce output, you increase prices. And so courts see through that, right? They see that a restriction of output in and of itself can violate the antitrust laws if you agree to it, if competitors agree to a restriction of output. And in your case, a restriction of output would be a restriction of hours that you can provide your services. So it really depends on the nature of the restriction, right? The way I would think of it, I don't know if this is helpful, but the way I would think of it is right now, as you see each other's faces on these screens, technically the way the law sees you is you're all competitors with one another, right? Even if you all like each other. Right? You're all competitors of one another, and any agreement you all come to restrain your output or to, only provide your services for at a particular rate is price fixing. And so, things like, the trade association saying, like, because of COVID, we are concerned that interpreters could be in circumstances where they could be at risk of infection. And so we, as a trade association, advise that interpreters only work in circumstances where there's sufficient PPP or whatever, right? There's sufficient equipment that's protecting you, and that as much as possible you provide your services over Zoom or some other, socially distanced medium or something like that. That's totally fine, right? Because that's about, the quality of your services and maintaining and protecting your members, so that you're not vulnerable to harm, right? But where it gets tricky is when you start getting into anything relating to your output, the hours that you work, or anything close to sharing the costs of your services or the rates that you charge.
Or for example, in federal court, there's a standard where if there's a trial and they have to have two interpreters because of interpreter fatigue, and that really affects the quality of the interpretation.
Yeah.
But when we have state court trials, it's the Wild West. So can we as an association say we recommend that our members only accept trial hearing assignments if two interpreters are assigned to safeguard the quality of the interpretation?
I think that would be fine, right? So if you say, yeah, like because of fatigue issues, right, and to ensure the quality of our, interpreting services, it is best practices to have two at any given hearing of this length. Yeah, that's fine. But if you order people to do it, it's a little bit, that can be a little bit tricky, right? You just
We
want to make,
can't.
yeah, you just want to make sure that you're advising that if you're the trade association, you just want to make sure that you're advising people in a way that is defensible through the quality of the services that you're providing, and that you're not mandating or requiring that everybody do it.
Right, just recommending.
Yeah, you're recommending or advising that that's best practices.
Well, fantastic. Um, I really wish other people would come in and ask questions. I see Deborah Spector. She asks a lot of questions a lot of times. You want to ask a question, Deborah? Hold on. Let me see if I can figure out. Um, you're on mute. Oh, there you go.
I don't have a question because unfortunately I had to come in late, so I missed the presentation before we got to the question and answer session. So I won't have any questions until I can see the slides at least. Thank you.
Oh, sure. And thank you, Deborah. So if you do review the slides and you want to get in touch with me with your questions, just feel free to email me. My email is on my BC Law website.
Excellent. Thank you.
We have Andres Besulam with a question. Go ahead, please, Andres. Hold on. I don't know if I have to unmute you or you can unmute yourself. And please excuse my lack of knowledge.
Here we
There
go.
you go.
Okay. This might be a little bit off what we're talking about, but we also suffer from a lot of, let's say, competition from people that are not certified as we are. And it takes us a lot of time, money, and effort to become certified. Yeah. And once we get this competition, we have absolutely no protection because even the laws that are there to protect us won't be enforced by the people that have to enforce them. Mm-hmm. So always, again, trying to find an alternative. There's a difference between being certified and have a certification than to have a license as a profession. Mm-hmm. Because when you practice something that you need to have license as a professional, it's actually a criminal offense. Mm. And this would be a great deterrent for us that have invested so much time and effort into becoming a certified interpreter. Right. Is there a possibility that we could somehow lobby ourselves to become a profession and have a professional license?
Yes, absolutely. Yes. So, and this is what physicians and physicians and lawyers do, right? It's like we have these legal cartels where we've created licensing requirements, and that we regulate our professions through licensing, and we have our own licensing boards. Right. And I'm sure you might even know people who have served on these boards in various settings in other professions where you can discipline people if they practice without a license. And obviously, yeah, it can be, under state law can be a criminal offense, but those are all creations of state law. Right. And they're all state regulated. And so that would be something that you could look into. establishing licensing provisions and licensing boards to potentially elevate the standards in your discipline and ensure that people who don't have those that level of expertise or certain levels of or who might violate the licensing requirements would not be allowed to practice.
So the way I understood it is that the granting of these licenses is done by the states. Like if, for example, you're a contractor, so you cannot do a roof without being a licensed contractor, because if not, it's the state that will go against you. Now, this is not our case because we're not here or there. Who gives us our certification doesn't enforce, and we're not on the other side. Now, we happen to have a state senator, and the actual state senator, which is herself a translator and an interpreter, or was before going into politics. Can she be leveraged to work something of this sort?
Absolutely. Yeah. And what you can do is I think it's worth potentially researching, right? Like, how have other professional associations established licensing laws and licensing requirements in your state? And look at the history of that and the provisions that they've established under state law. And you could basically use that as a model for your own draft legislation, right? To say, we want you to put this bill forward and to pass this, and we want to establish a licensing board. The licensing board would look like this. It would impose these standards, right? And the standards would be maybe similar to the types of rights that you would have as a licensing board to discipline people who are practicing without a license, right? All of those things could be modeled on existing licensing boards, so that what you're asking for sounds reasonable, right? It's like, all these other professions have licensing boards, why not us?
Thank you, Doctor.
Well, we are at the 1 hour and 45 minutes mark. I can continue asking questions all the way to 2 hours, but we have a question here from
Yes.
Angela. Please go, Angela.
Okay, this is not a question. This is a remark. A lot of the people in the session are not asking questions because they have not figured out that they need to click on participants down below. And once you open participants, there's the option on the lower right-hand side to click raise your hand. So it's not a question, but it's a remark that came through the WhatsApp that,
No, yes. Please raise your hands. So if you have
just raise your hands visually.
yeah, that too. And
usually it doesn't work because some of the people do not have the camera activated. So you would need to go more through the raise hand for those that don't have the visual.
But anyway, maybe we saw somebody. No.
If people want, I don't know if you all are WhatsApping, but if people want to WhatsApp Angela, if you want us to unmute you to ask a question, we could do it that way too, if that's easier for people.
Exactly. So if because we actually have an ATIF WhatsApp chat, and I think people have been saying a lot, but I just haven't been able to look at it as we're doing it. But anyway, yeah, Carolina Thomas has given some pointers as to how to get to your slides, and we're going to share your slides via PDF into the chat via email as much as we can. I don't know if you can give us some basic takeaways, like what would be the 5 main conclusions going away. And I like what you said earlier, that compared to Uber drivers, we have a lot more leverage.
Yeah. So I think takeaways. So I do go through some takeaways on the slides, and that I think might be the best way to get takeaways in terms of, and the second to last slide covers what's unlawful to do as competitors with each other, but what's lawful to do as well, right? And so it goes through that. And basically the two things that can be lawful, where you can coordinate with each other as interpreters, is if you're considered employees and you come under the labor exemption from the antitrust laws, which is unlikely, or if you form a corporation or some form of business organization and you work together as a single entity, right? And unilateral conduct under the antitrust laws. So coordinated conduct, unlawful. Unilateral conduct by one firm, lawful, right? So if you engage in unilateral conduct, meaning as a corporation, you decide what rates you want to set for your services, you decide the terms and conditions for the provision of your services, that is lawful, right? Any corporation can do that in this country. Any corporation has the right to do that. Oh, I noticed that Adriana has her hand up. Oh my goodness. And
Maria, Maria Olga Villasana just put up her hand. Maybe we can unmute her. Let me see if I know how to do this. And there you go. You need to press unmute on your own device. There. Oh, you did, and then you're muted again.
No.
Try it again. Unmute. There we go. You're on.
Okay. This might sound like very basic and very straight to the point, but I mean, my question is, so agencies can charge whatever they want for our services and there's nothing we can do about it?
So, okay, there's two things you could do about it. Three things, I would say three things you could do about it. One thing you can do about it is you can, by yourself, say, I don't accept these rates. I charge these other rates. You can make a counter offer. If they have a lot of power, there's not a lot that your counter offer is going to do, right? So, and I'm sure you've all tried that and it doesn't work, right? Okay. So that's one thing you can do. The second thing you can do is potentially strengthen your trade association, but you would have to make sure that you do that through state law, right? Even as a trade association, you can't set uniform prices. That has been found to violate the antitrust laws. The third thing you can do is you can all come together and form a business organization together, right? As one single firm. And you can file there's a menu of options for business entities or business organizations. You can form an S Corp, you can form an LLC, you can form a partnership together, you can form a workers' cooperative together. These are all basically standard form, they're essentially a set of contracts that function as defaults in the law, right? That get certain types of protections under law, right? You get certain tax exemptions and tax protections, certain liability protections or whatever. If you form a corporation, some of you might already know this because some of you have already formed LLCs, right? But if you do this all together and you all come together and form a single entity and you say, agencies, you want certified interpreter services, these are the rates for those services, this amount per hour, that you can do. And if you have the collective leverage together, right, what are they going to do if they don't like your rates? Who are they going to go to, right? It's true, they might go to non-certified interpreters. They can only do that for certain types of services though, right? Like I imagine in court, they won't be able to use those folks, right? And so you will have a certain amount of leverage. Also, right, in your corporation, you can be all inclusive, right? You can hire whatever employees you want. You could even hire some of the non-certified interpreters if you want, right? And those people will be will add to your market leverage, right? Because then you will be able to limit your clients' outside options.
A continuation question. So I can form a corporation with 2 colleagues, 3 colleagues. Mm-hmm. Is it legal for me to form a corporation with 4 colleagues and and we go offer our services to independent lawyers and we're going to charge $100 less than what the agency charge? Is that okay?
Yes, Yes. So you could form a corporation with just 4 of you, or you could form a corporation with all of you on this call, right? You can form a corporation of any size. And it really will depend, like how much of you are going to be, and depending on the type of business organization, you could decide that all of you are going to be owners of the corporation, right? That's more like a workers' cooperative. Or you could decide that you want only a certain number of you to be majority shareholders of the corporation, and you can issue shares that each of you would own, and you would have a certain, power to make decisions on behalf of the corporation. You can designate minority shareholders, right? There's all sorts of ways that you can structure the governance of the corporation, but it can be of any size.
Thank you.
I think Monica Gelman raised her hand, so let me see if I can figure out how to do this. I think you're on, Monica.
Yes. Well, thank you so much, Hiba, and also Javier for putting together this presentation. I think it's great. Well, one of the questions I have is that with all these virus, at least most of the positions and legal events have gone virtual. So what I've been seeing is, and I don't know if other colleagues have the same, but I saw in some chats or in Facebook groups that apparently it's something common, is that our rates have gone significantly down, about 33%, 35%. I mean, even though we have negotiated rates with agencies, but because of the virus, and I don't know if there is more demand, less demand, they are going down in our rates, what they are paying us. Is there something that we can do? Because again, it's a virus, it's a pandemic. It's the opposite of price gouging, actually.
Yes. Okay. So, so when you say agencies, can I just clarify? When you say agencies, are you talking about state agencies or?
No. And they not necessarily are in Florida. They are Florida. They can be in California, in New York. They are companies that they hire you to perform interpreting services that you have worked for many years, and now because of the virus and because you are not going in person, now they want to pay you less. Yeah. And it's not like 10%, it's something 33%, 35% less.
Yeah.
When you have actually higher costs, and actually it's harder because now you have to do everything consecutively. You have to invest in equipment, in headsets, etc. So I don't think it should be that way.
Yeah. So with respect to that, I would say there's the two things that come to mind that you could do. One of them is, and there may be more things, but just off the top of my head, one of them is there are consumer protection laws that state attorneys general enforce that prevent price gouging, right? Mm-hmm. And so to the extent you can petition your state attorney general or other government officials to say, this is price gouging as a result of the pandemic, and we want you to intervene and help negotiate on our behalf, or, actually, potentially charge these particular companies with price gouging, right?
As it is the opposite, they are paying less, not more.
Oh, no, that's okay. It's predatory regardless, because, okay, so this is something, and I teach antitrust law. Mm-hmm. So this is something when I like teach and my students are like, that doesn't make any sense. This is, so exactly. So, okay, so you can have market power on the buy side, or you can have market power on the sell side. So if you have market power on the sell side, right, where you have, you can determine whatever price you want for selling your goods. Like you can charge really, really high prices for, selling whatever, a particular drug, for example. That can run afoul of the antitrust laws. You can also have buyer power on the buy side, market power on the buy side. And that means you get to engage in what's called predatory pricing. Right? So you can set because you have so much market power on the buy side, you can say, I'm going to buy your services for much less, even below the cost of you producing it, because I have a lot of power and I can do it. Right? And that can also violate the antitrust laws. And to the extent they're doing it in a way that's where they're coordinating, that can violate the antitrust laws, but also they could be potentially running afoul of consumer protection laws as well. right? And so you guys also have the power to sue other people for antitrust violations, right? Like if you think that all of your clients or the people or the agencies are themselves engaging in an antitrust violation by coordinating and colluding with one another to suppress the prices they're willing to accept from you, that might violate the antitrust laws. This is a really tricky area right now in the pandemic because a lot of companies are facing crisis. And so they have been coordinating, and what they've done, what certain industries have done, is they've petitioned the federal government to give them exemptions from the antitrust law for coordinating with each other, right? And so what they've done is they've filed what are like they've requests for guidance, which are essentially petitions to the Department of Justice and the FTC, asking them if we do these things, would that violate the antitrust laws, right? And so far, the Department of Justice and the FTC have said that when medical companies coordinate, when drug companies coordinate, and when essentially PPE, so like, you know, the companies that make the protective gear and face masks and stuff, when those people coordinate, that's okay for now. And it's only okay in a temporary basis for those companies to coordinate. Everyone else, the federal government has not said it's okay for them to coordinate. So if these agencies in fact are coordinating and agreeing on charging you lowball prices, that could violate the antitrust laws and you could file a suit against them. The other way that you can fight back is to form a corporation and say, you know, like, you know, you're giving us these prices as a single corporation. We're only going to provide our services at much higher prices.
We have a question from Adriana Dominguez, who is one of our volunteers. I want to thank her personally for all the help she's given us together with Carolina Thomas. Here you go. I'm sorry, I keep on screwing it up. There you go.
Great. So I asked you this question yesterday, Professor. What would you do? Which entity would you choose? I know you're leaning toward all of us incorporating because there's the strength is in the numbers. Would you use a cooperative entity, a co-op, or which one would you think?
Yeah, okay. So this is a super tricky question, and I think it really depends on all of you and how you all work together. I think that workers' cooperatives can be great because they allow for genuine self-determination and self-governance by all of you, and you each have an equal voice. You know, that can be really costly though, right? So to the extent it could be the case, for example, that there might be some people who are really, really good at making certain types of decisions and at strategizing about, you know, particular ways of moving the profession forward or moving your, you know, trying to expand your market share and things like that. And you might not be as worried about all that stuff, right? You might not love the governance stuff, being in all the meetings, you know, talking with the lawyers, handling, you know, accounting and administrative stuff relating to the corporation and things like that. That just might be burdensome for you for whatever reason, right? You might have a family, it's not a priority for you. You just want to make sure you have, you know, that you're getting the actual value of your services, of the time that you invest in your work, and that's all that you care about. In that circumstance, you might want to have a different type of structure, right? Instead of a workers' cooperative, you might want to have like a partnership or an LLC or something like, or an S corp or something like that, where you might not want to be on the board of directors. You just want to be an employee. You want to make sure that you get, you know, the terms that you want for your work. And, you know, if you, so it depends on the culture of the group. You know what I mean? And like how active and involved everyone wants to be. The other cost of it is coordination costs. So if you think that you all might really disagree with each other on all sorts of things in a way that might hold you back or take a lot more time to get to effective action, then you might want to just designate certain people to be in charge and make sure that it's representative of the different views that people might have, so that just like in our government, right?
Like an
It's
election?
a smaller number of people that are delegated to make decisions.
So like an election? An election?
Yeah, so you can think of a corporation just like our Senate or just like our House of Representatives. You elect the members of the board, right? The shareholders, and you would all be shareholders. You elect the members of the board. You get to decide who's in charge. So it is just a democratic institution, and the rules that govern would be the rules that govern as a default under corporate law, and then some corporate organizations or business entities have more and less democratic participatory structures. But that being said, right, in your articles of incorporation, you can design whatever governance structure you can within the law, right? So you can say, we want to have board elections every month, or we're going to have board elections every year, right? And you know, within the parameters of the law. So you can decide, and you can decide what percentage of shares you want to issue. You can decide how many shareholders you want to have. You can decide what power, what voting rights various shareholders have.
Could you reiterate again, because I know there's questions about this floating around. Why is it better to have all the people in this corporation rather than 3 or 4 of us incorporate?
Yeah.
You said it, but if you could repeat it.
Okay, so the thing that's empowering for all of you in being a corporation altogether is that you have, so this is the thing. You want to imagine this as an issue of bargaining power. You all want bargaining power, right? What's your bargaining leverage if you're one person versus if you're 100 people? It's pretty small, right? What's your bargaining power if you're 3 people rather than 100 people? It's a bit stronger than 1, but not as strong as if you're 100, right? If you're 100 people that can bargain with the agencies, right, rather than one person, right, you have a lot more bargaining leverage, which means you can push back against them and have more bargaining power when you're trying to set your rates for your services. The more people you have, the more leverage you have to get higher rates.
Right. And the discussion of the working conditions and the rates can be had after that corporation is created. Is that correct? Not before.
Yeah, so what you'd want to do is you'd form the corporation, and then once you form the corporation, you would set, okay, well, what are going to be the rates that we're going to set? What's the pricing structure for our services? And you set that as a corporation.
Got it.
And we can also say, let's say we only do 2-hour minimum, half-hour increments, whatever.
Yeah. Yep. Anything that's unilateral, right? You all of that is unilateral conduct. You can do it. You can decide the terms and conditions of your work. You can say, you know, we're only going to provide our services under these safety conditions for this amount of hours or whatever it is.
Well, I think we've come to the end of our Zoom here. We really want to thank Professor Hafiz. We've been fascinated by your presentation. I also want to thank our interpreters, Carolina Tomas and Adriana Dominguez. Without them, I don't think we could have put this together. And we'll put an end to this. And I say thank you, everyone who's participated. And please excuse all the technical issues because this is completely new for many of us. And we'll do better the next time. Thank you, Professor Hafiz.
Thank you very much.
It was such an honor to meet all of you.
It was an honor having you.
Yes, it was our honor. Thank you, and we'll end the meeting now, and everyone have a good weekend. Bye-bye.
Bye.
Bye-bye.